Good morning. Happy Friday. So, Maddie has come out with some more information. She's clarified a few things for me. Doesn't change a darn thing about the principles of law that I was talking about yesterday. And in fact, if you apply those principles of law to the new information that she has provided, you will see that very quickly she's not in a good position. Unfortunately, the issue she's raising money for is not the First Amendment issue, whether or not she can record the speech of government officials, like on a phone call. The issue is whether or not she can be convicted on the state stop and ID statute for failing to produce identification after the cop apparently arrested her or wanted to cite her or whatever he did. And that's much less interesting, much less fun. The Brown v. Texas is satisfied because the state has included the language in the statute that requires the officer to have at a minimum reasonable suspicion before he can demand ID, before you are in violation of the law if you fail to produce ID when the officer demands it, I should say. Officers can always demand ID. It's whether or not you can get in trouble for failing to produce it is the issue. And if he has reasonable suspicion and you fail to produce it, then you can get charged and potentially convicted. In this particular case, there has been a probable cause hearing. And as I said yesterday, probable cause is a higher standard of proof than reasonable suspicion. And therefore, it's been established by a court that there was, at a minimum, probable cause. So that's going to be very problematic indeed for the appeal. The second thing is that Maddy seems to be under the impression that she proved beyond a reasonable doubt that the officer could not have had reasonable suspicion or something. She said some weird standard of proof thing that no reasonable person could have blah, blah, blah. But she said she proved it beyond a reasonable doubt, and that's not the way it works. Once again, from my video yesterday, if you remember, it is the prosecution's burden of proof to prove beyond a reasonable doubt that the defendant is guilty. Those words all have meaning. The prosecution has the burden of proof. The court is only looking at, did the prosecution prove beyond a reasonable doubt the defendant is guilty? If yes, then guilty. If no, not guilty. The defendant doesn't have any burden of proof, can prove everything, can prove nothing. It doesn't matter. The only issue is, did the prosecution prove beyond a reasonable doubt the defendant is guilty? So, despite what Maddy thinks, she didn't prove anything. There's, again, no standard of proof. What happened at court was that the prosecution failed to prove beyond a reasonable doubt. But that doesn't mean there wasn't probable cause, and that doesn't mean that there wasn't reasonable suspicion, which means that she could still get nailed for the failure to ID. So, I hope that clears things up. Good luck, Maddy. Thanks for watching. Have a great day.